And now I have my colleagues who are going to help me remove the furniture of the stage. You think it's difficult to adopt EU law? You know, try creating a script for an EEA seminar. Okay, excellent. Thank you. Thank you so much, guys, for all the help. Then I'm going to, so now we've talked about the Secretariat. How do we adopt the law? What happens in the ministries, in the member states? But what happens after the law is incorporated into the EEA agreement? The role of the Secretariat ends there, but obviously for a market that functions and is homogeneous, it's not enough that the rules are the same on paper, they also have to be the same in practice. And so the next presentation that we're going to have is from our colleagues, our sister organizations, the EFTA Surveillance Authority and the EFTA Court. The EFTA Surveillance Authority monitors the compliance of the EEA agreement in Iceland, Liechtenstein and Norway, and the court is given the task of interpret any disputes that come up on the incorporation or on the interpretation of the rules. So Melpo from the EFTA Surveillance Authority, Oliver from the court, please, the floor is yours. And I'm going to give you just 2 mics.
That's how cooperation works. Hello, everyone. I'm Melpo Josefides. I am the director of the Legal and Executive Affairs Department. So I have 2 hats in the EFTA Surveillance Authority. I am ESA's jurisconsult, so the legal advisor and representative in court, and also the head of the department that coordinates decision making.
Yes, so thank you for inviting us. My name is Ólafur Einarsson. I'm the registrar of the... This one works. The registrar of the EFTA Court, which is a court lingo for saying that I'm in the term highest ranking official, so not, of course, member of the court, but official. I am responsible for the administration of the court, all sorts of procedures, and in a small institution like the EFTA Court, I also get the opportunity to speak at conferences and take care of all sorts of other things which is necessary to run the court. So Melpo and I, we will take you through our institutions and a bit sort of what happens with EEA law once all these procedures have been completed. So then we start, and we will try to divide, then try not to mess up our division, but bear with us if we do.
Yeah, we're improvising this duo, so watch us as we go and please smile at us. So we'll be talking about enforcement. It's important once the rules become part of the EEA agreement that then they become a reality. And they become a reality because the EFTA states have taken the engagement, the decision that once they agree with the EU that something will be part of the EEA agreement, that then this will be part of the national law and applied. That's a way to ensure sovereignty. There is this check that it's always up to the states to make those laws part of their national laws. So what we do in ESA is we monitor that these laws have become part of the national laws, but also that they are applied correctly. And both of our institutions operate on the basis of these 2 instruments. One, the EEA agreement, which is between the EU on the one side with its member states, and on the other side, the 3 EFTA states. And on the basis of the surveillance and court agreement, which is purely on the EFTA side. So what happened is that the EU and the EFTA side agreed that there will be institutions put in place so that the EEA agreement is policed and developed and checked. And for that, the EFTA side has its own surveillance authority and EFTA court.
And then we see the most used slides of this morning. I think I counted this the 5th time, but I'm skipping the EEA forum, which Peter had at the bottom. But you notice then we are now in the middle. So we started this morning at the top with sort of more the political dimension, and then Peter took care of in his view, the most important part. I would tend to disagree, but let's leave that aside. So now we are in the middle with ESA and the court mirroring the European Commission, essentially the surveillance function and decision-making of the Commission, and the court mirroring the Court of Justice of the European Union. And I think it's important, there is a void. You've seen in the other slides, there are joint bodies. Here, the EFTA states are self-policing. So they have created these independent institutions responsible for the surveillance and the judicial mechanism of the agreement without the involvement of the EU states. So that's why I think it's important to underline self-policing, which has now worked, I would argue, successfully for 30 years. And it also shows that these, of course, the surveillance authority on the one hand and the court on the other, these are, of course, independent institutions from one another, but they are part of the same value chain which makes the EEA agreement work. So, and then we turn to putting a face to these institutions.
Yes, and if I may add on the previous point, it really shows the importance of trust to make the EEA agreement function. The ESA and the EFTA court, when we fulfill our role independently and fully, that's when the EU can take care of its side, and basically the 3 EEA EFTA states have us as counterparts and do not have to deal with the EU institutions when it comes to the enforcement side of things. This trust has functioned very well, and we have leadership in ESA, which is representing the 3 states. In the middle, you see Arne Roxen, our president, who was nominated by Norway. All of the college members are nominated, each of them by their state, but the decision to appoint them as a college is taken together by the 3 EFTA states. So they have the backing from the 3 EFTA states. You have Arnipal Arnason from Iceland and Stefan Berriga in respect of Liechtenstein. Now, these people were, of course, appointed from those states, but I cannot underline it enough. Our college members and president act independently, don't take instructions from the states, and bring to ESA the understanding of how the states function and very good tools as to how to have that dialogue with the states and make sure that compliance happens.
Then we come to the institution of the court, which is also a 3-member institution, and it's the same as with the surveillance authority, that each state nominates 1 member, and they are then appointed jointly by the 3 EFTA states. So currently the court is composed of Páll Hreinsson, who is the president from Iceland, Bernd Hammermann, who is the judge from Liechtenstein, who used to be a college member for a very long time ago, which shows that he was the first college member for Liechtenstein back in 1995. And Norway recently appointed a new judge, Mikael Reiertsen. So they always sit 3, so there's 1 chamber of 3 in every case. There's no chamber of 1, and they decide all cases together. And we will discuss, since we're a little bit short of time, I'll touch on the jurisdiction a little bit later.
So now we go back to how ESA ensures compliance with EEA law in the 3 states. We have some tools as to how to investigate, and to those who know a little bit about enforcement by the Commission, this will sound familiar to you. So there's, of course, general monitoring. We're reading the news from Brussels, but we're reading the national news and seeing if there's any issues with the application of EEA law that become obvious there. Some of the pieces of legislation that were agreed to have reporting obligations, so the ministries will have to send us information as to how they have dealt with a certain matter. We do conformity assessments for certain pieces of legislation. That means that we take the EU laws as incorporated into the EEA agreement and compare notes with the national laws in the 3 states. It can be all of it at once or specific parts of a piece of legislation. And sweeping this legislation this way allows to already see if there's any structural problems. That is very resource intensive, and we don't have the capacity to do that for all pieces of legislation, but it is a very useful tool. We have the obligation to receive complaints. So any individual or a business in anywhere in Europe in the EEA can complain to us, ESA, about any of the 3 EFTA states and explain why they think their EEA rights were not respected. And then ESA decides whether to follow up on the basis of that complaint or follow up on the issue in general through other means. And one of the other means are the own initiative cases. So these are cases that we, our colleagues in the Internal Market Affairs Department in ESA frame and take up and start a dialogue with the states in order to check whether there is a breach and make sure that we reach a positive resolution. So there are some formal steps. Again, this will be familiar to those of you who know about enforcement in the EU. The first step is there's always, of course, a dialogue throughout the procedure. So our stance in Brussels is not to take a distance and say we're going to make sure that you correct all errors and we don't want to hear anything about the reasons why you took a certain course of action. We want to understand what are the reasons that are driving certain choices at the national level. And very often, as part of that dialogue, we actually help the states come up with solutions to the problems. So there are often many reasons, political reasons, local considerations that drive certain choices. And what we try to make sure is that the choices fit within the EEA agreement and do not breach any of its rules. But if that's not happening, then we send a letter of formal notice. That is a letter that contains the reasons why we think there is a breach. And we give the states a chance to respond. If we get a response that's not satisfactory or steps that were taken were not enough, so the issue remains unresolved, we move to a reasoned opinion stage, which is the part that is really regulated in the Surveillance and Court Agreement and in EU law. That is the last chance to basically resolve it before we go to court, and we give a compliance deadline by which the state has to respond saying they have complied. When compliance doesn't work at that stage, then the question is, do we move to bringing the matter to the EFTA court? And Olafur will be speaking about that. Our deadline for compliance means that there is a time pressure for the state to come into compliance. So it's better to always resolve matters before we reach that stage. But even if we've had a resolution after the deadline, it's not an objective per se for ESA to bring a state to court to have a declaration that they have breached the rules in the past if the situation has been since then corrected. So we use referrals to court sparingly, and also because in many cases the states comply earlier. Yes, I also wanted to, as a transition between my part of the presentation and yours, Olafur, I wanted to show a little bit where the EFTA court has placed itself, because the case law of the EFTA court is basically the guidance for us in ESA and in the states as to how to comply with EEA law and what to check when we are checking compliance. So the EFTA court has said that the EEA agreement is special. It's a sui generis, it has established a sui generis legal order. And what the EFTA court has done there is a bit like what the ECJ has done. It has placed itself as the arbiter of what the consequences are of the EEA agreement. So if we have a question as to the extent of obligations of a state, we might as ESA have our own thinking of how far a state should be going to be brought into compliance. But the ultimate judge of that is the EFTA court, and the EFTA court defines rules.
So I'll leave this on for one. This is if you read one case of the EFTA court, you should read this case. We have submitted the reference there, E997, Erla Maria Sveinbjörnsdóttir, establishing state liability as a matter of EEA law. The judgment is from the 10th of December 1998, so it's celebrating its 25th anniversary very soon. And there's another important judgment handed down on the same date, which I will mention at the end of this. And then, of course, this is just an avant-goût for those who registered for our workshop, where we will explore this a little bit more. But then very briefly on the legal framework and the type of cases the EFTA court deals with, which is sort of a follow-up on what Melpo has been saying. As we had at the very beginning, we have the EEA agreement and the surveillance and court agreement. These are the agreements that govern the operations of these two institutions. And both, here I picked the provision for the court. There are similar provisions for the surveillance authority that as a matter of, under the EEA agreement, the EFTA states committed to the EU, we will set up a court and we will set up a surveillance authority. And the surveillance and court agreement, which is an EFTA instrument, by and large inspired by EU law, discharges this obligation. And then they further flesh that out by the statute of the court, and then the court has enacted its own rules of procedure. These are technical issues which we won't go into, but again, these instruments are by and large inspired by EU law, although of course they reflect a bit of peculiarities and the size of the institution. So the jurisdiction of the court is to rule on the agreement, and the agreement is of course both the main part and all the legislation which has come into the agreement via the processes we have been learning about this morning. So then there are two types of cases for the court. One, we have the direct action, and here we are really following up on the slide from Melpo on the infringement procedure. So one, direct actions are two, and that the road forks, and ESA is really the key player in both of these actions. One is the continuation of the infringement procedure. As has been explained, they start with an informal phase, then a more formal administrative phase, but they culminate in the court being seized of the matter and then deciding on is the state in breach or not. These cases, many of them concern late implementation of one of the many acts incorporated into the agreement, and there the outcome is really not in doubt, but then also they are very high stakes and complicated cases. ESA has recently, for example, referred a very substantive case on the right to healthcare in other EEA states, where ESA alleges that Norway has not complied with its EEA law obligations. As a matter of curiosity, I refer to Article 32 of the SCA for those who are interested. An EFTA state can sue another EFTA state in front of the EFTA court. It hasn't happened, and I think if the agreement lives another 30 years, it still won't have happened. But maybe those are famous last words. Then we have the other type of direct action, and there ESA is not the applicant, but rather than the defendant. These cases are on validity of ESA's decisions, and they are, for all intents and purposes, about state aid. There have been two very high-profile competition decisions challenged, but mostly this is about state aid. So that's a field we haven't touched upon and we don't have the time to touch upon, but is worth mentioning very briefly. Then we have the other type. And again, for those familiar with EU law, this will be familiar. This mirrors the preliminary ruling procedure. Preliminary ruling is then requested by a state court in a member state of the European Union and then goes to the Court of Justice. Similarly, courts in the 3 EFTA states can refer questions to the EFTA court, who will then render an advisory opinion. So this is not a case initiated by, like the direct action ESA or against ESA. This is a case pending before a national court and concerns EEA law issues, and the national judge refers questions to the EFTA court. And again, if you remember Marit's favorite slide about sovereignty, this is really where the sort of the binding nature of the ruling, which was essential for the preliminary ruling procedure, and the sovereignty concerns of the EFTA state meet. That's why these are called advisory opinions. I have on the right-hand side of the slide, at least seen from myself, the effect. Are they always followed? I put always between speech marks. I think that's almost true that they're always followed. This is one of the things we explore this afternoon, but I think leaving aside the formalities, the result is more or less the same as with the preliminary ruling procedure. Then our final slide is the key word of the EEA agreement. Finnur emphasized it many, many times: homogeneity. Same rules interpreted and applied the same. And this judgment, Rainford Towning, is the sort of little sister of the Erla Maria judgment. It's handed down on the same date, 10th of December 1998. And there the EFTA court was faced with quite a robust challenge to the understanding of homogeneity by Liechtenstein, and it answered in a very unequivocal fashion, saying, if it looks the same, it smells the same, it is the same. Essentially, if you have a provision of EU law taken over into the EEA agreement, the main part, or one of the acts incorporated, the starting point is always, it means the same, and it's something very, very special for it not to be the same. We will touch upon that maybe a little bit in our workshop, but that's very, very rare. This was our last slide.
Thank you very much.
Thank you.
Thank you. Wow, now I have 2. Good. So we are going, we have our next speaker here. We're running a bit into the time. So I'm just going to see if there's one question here. Otherwise, I'm going to let you talk to Melpo and Ólafur during the lunch. And of course, they will also run one of the workshops this afternoon. Then I think in the interest of time, I'm going to say thank you so much for the presentation. Very good impromptu partnering and cooperation. And there are quite a few lucky ones that will go to the presentation this afternoon. Thank you. Now we are entering the final part of our morning. So just to take you back a little bit, we've talked about why this matters. What is the political drive behind this cooperation? Then we've looked at the work that has to happen to ensure that the agreement is respected and it is functioning as it should. But I want to go back and mention what our representative from the EU Council mentioned, because he talked about the EEA and Norway grants and how important it is for him that you can go and visit small plazas in Spain and see this mark, this cooperation. And as he said, it goes far beyond money. It is collaboration, it's building knowledge, it's building partnerships. And we are very, very happy to have here with us today Ragna Fitzdøl. She's the new managing director of the EEA and Norway grants, and she's going to tell us a little bit more about their work. Ragna, welcome.